I'll tell you what, we'll get started. Okay, folks, this is Mary Sue Lanigan. I'm with the Michigan Parkinson Foundation. I want to thank you all for joining us this evening. Tonight, we are going to have a discussion about Social Security disability benefits. We have an attorney named Kerry Spencer, who is with for Social Security Rights, and she's going to talk you through the process. Kerry, you want to just kind of wave to everybody? Because once
Hey, how's it going?
Yeah. Okay, folks, I'm going to mute everybody. Once I do that, Kerry, you need to unmute yourself because I can't do that. All right?
Can you hear me? Yeah.
Yeah, I'm going to mute everyone now, and then Kerry, you unmute yourself.
Gotcha. Okay, I'll get started then. All right, I'm a Social Security lawyer, and I have been since 1986. I've worked for the law center that long. I'm very involved with the state bar. I'm vice chair right now of the Social Security section, and I've authored a book on Social Security. I have written blogs. I'm very involved in this area. So on the first page, you can see my email there. If you ever have any questions, don't hesitate to send me an email. I'm really good about responding. And part of it is I really enjoy this area of law and I know a lot about it. I am going to try to tailor this a little bit towards Parkinson. I figured that's something that would be very relevant and helpful.
Kerry, I'm trying to share your screen. Can everybody see it?
Okay.
I'm struggling a little bit for some reason.
Yeah. It's all right. I can still present it if you can.
Okay, keep going until all right,
okay.
Go ahead.
All right, so I'm sure maybe you don't know, but there's two different types of Social Security disability. The first thing you want to know is that there's something called SSD or SSDI and SSI. You might hear both of those words out there. SSDI is probably what you're going to be filing for because it's based on your work credits and what you've actually paid in FICA taxes over the years. It's kind of like the insurance policy. SSI is not. You don't need any work credits for SSI, but you need to have limited income in your household. So both of those programs have the same medical standard to meet Social Security. It's just, and sometimes people can file for both at the same time. If your monthly amount is so low, you could file for SSI and SSD. All right, and we have the PowerPoint. So you can go to the next slide, slide 2. That's kind of what I was just going on over. And by the way, if you want to email that PowerPoint to everybody, so the PowerPoints they're very wordy because I'm kind of a wordy person, but I also want to make it so you can maybe refer to it later and it'll be a helpful guide. The next slide about comparing the two programs, sort of reiterating what I was saying. SSI is a needs-based program. SSD, although you have work credits, your work credits expire. So that's something to be aware of. You don't want to stop working and file more than 5 years after when you stopped work. Okay, so we're on the slide. No, back up one slide about the definition. There we go. All right. Now, Social Security has a fancy definition because us lawyers love words and making people try to understand what we're trying to do. And but this is what the definition of disability is. The inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to last in death or for a continuous period of 12 months. Okay, that is in a nutshell what we are trying to show. Now, every little word in there has a definition because we're lawyers, okay? So SGA has a meaning. The continuous period of 12 months has a meaning. So you know, it's a little bit harder than it looks as far as qualifying and meeting all these definitions of what disability is. should go to the next slide. There are two ways, and this is just a really brief overview I'm giving you. I mean, you got to understand this is an administrative body of law that's pretty complicated and niche. So I'm just giving you a basic overview. There's basically two ways of qualifying for disability. The first way, and we're going to go over that, and this is where most Parkinson cases, in my opinion, fall under, and it's called the listing of impairments. And we'll go over that in a second. The other way is basically showing that you're unable to sustain full-time competitive work, which means 5 days a week, 7 hours a day. And you basically have what's called a residual functional capacity form that shows you can't do that. So this is just more general stuff to get into the definition. Remember I said you can't be engaged in substantial gainful activity? Well, you can't be working. You can't work if you file for disability. The first thing they're going to ask you is, are you working? Well, what is work? Work means dollar amount to Social Security. So if you're working and you're making less than $1,260 gross a month, you can file. That's not going to be SGA. So if you're making $1,261, you're going to file for disabilities, and you're going to get a denial within a week and saying you can't file because you're working. Okay. So that's called a technical denial. So a lot of people will ask questions of how much it can work. I mean, if you come to me and you're working, I would say please don't work at all. Even if you're under the 1,260, it's still looked at, and it's not a good thing. You want to stop working if you're going to file for disability. Okay, you go to the next slide, please. I don't know if hopefully Emily got the handouts too. The RFC allowance. I made a handout for Parkinson's RFC, and you can actually give this to your doctor, and if you can get this filled out, it's so helpful to Social Security. I mean, you will be golden if you can get some of these issues just out there right away. An RFC allowance is, once again, just looking at what your residual functional capacity is, your ability to stand and sit and lift and things like that. And you're basically plugging in what those issues are with your RFC.
Kerry, can I interrupt you a minute?
Yeah.
I'm getting questions. What is an RFC?
Yeah, sure. In fact, you can just you can leave it on mute. If people want to ask questions on as we go, it's actually it's easier for me, I believe. But
the thing is, if we
it's too many people,
mute,
yeah,
it's too
okay, that's
noisy.
fine.
But what I'd like for people to do, they can unmute themselves if they want to ask a question, or they can put a question in the chat box, which is that.
Yeah, and then if you start to pile up on the questions, just interrupt me, stop me, right?
Okay.
Okay. So an RFC, once again, is a residual functional capacity form. It's a mouthful. And it's basically assessing your ability to do certain things. In the handout that I gave, it's not in the PowerPoint. I gave it's called a Parkinson's disease medical source statement, but it basically is an RFC. And it's pretty lengthy, but once again, these are legally very important things to know when you're trying to adjudicate a Parkinson's case. There's certain things that Social Security looks at as very significant. And I hope that answers the question. That's basically what an RFC, and obviously you have your treating doctor fill it out, an MD, hopefully a neurologist if you can. Can you back up to maybe slide 8 or 7? Yeah, 8 is good. Okay, so if you're not qualifying under an RFC, the other way to kind of do it is called the listings of impairment. And like I say, in my opinion, I think that's the most common way a Parkinson case qualifies for Social Security disability. A listing is a sure stop way. If you meet the listing, you're disabled. End of story. They don't look at your past work. They aren't evaluating what your RFC is. You aren't looking at whether you can do other types of work. If you meet a listing of impairment, you are found disabled. It's as simple as that. Once again, it's not that easy because listings have interpretations. So if you could go to slide 9, I'll give you an idea of what I mean. Slide 9.
Yeah, I know, I'm trying.
Yeah, no, it's okay.
For some reason, it's not advancing, darn it.
No, it's okay. I can tuck it in.
There we go. Okay.
Yeah, and I think, yeah, go to slide 10 maybe. I think that's where the Parkinson goes. There we go. Okay. If you have like a really helpful doctor, you could even give them a copy, and I made this in the handout of the Parkinson's listing, because a helpful doctor would be able to read this listing, and if they make a statement like, yes, this listing is met, you are going to be in really good shape. Just to look at it a little bit, the listing of impairment, and once again, this is actually from the federal statute. This is the law for Social Security Parkinson's for meeting a listing, and it's under 11.06. And you can kind of see, I mean, I know you're not lawyers, but this is kind of how statutes are set up. There's a lot of ands and ors and buts and everything, but it's pretty straightforward, I think. Parkinson's syndrome characterized by A or B, despite adherence to prescribed treatment for at least 3 consecutive months. And then you have to have either A or B. And under B, you need to have at least one of the following. So you can see in parentheses the 11.00C or the 11.00D. Each of those things are defined, and I gave you those definitions. So, for example, what do you mean by disorganization of motor function? They give you an example. Disorganization of motor function means interference due to your neurological disorder with movements of 2 extremities. And then it says, the fingers, wrists, hands, blah, 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 blah. So it tells you what you need to show. The definition is very set forth very clearly. Could you go to slide 11, if you can? And once again, I made this a handout just because it's kind of technical. It's very in depth, and it's the actual law. So don't feel bad if it seems sort of complicated. But once again, if you can meet a listing, you're going to be in really good shape as far as qualifying for disability. Are you able to advance it or not? It's okay if you can't.
I can. It's
okay.
Kind of hit and miss. So I apologize.
Okay. This is just more the definitions of the listing. Okay. Under what means areas of physical and mental functioning. They give you a definition of physical functioning. They give you a definition of mental functioning. You can go to slide 13. And once again, I know that's a lot there, and I'm not going to spend the time going through it, but if you sit down and you look at it, it makes sense. You know what I mean? Does anybody have any questions on the listing or any of that? That's in my throat. Oh.
One thing I wanted to say is, if you email me and you want these slides, I can send them to you tonight. Okay, so if anybody wants the slides, we can send that to you tonight. And we also have the form that you take to the neurologist to fill out to start the process. So I can send both of those to you. Just email me. I'm the person who sent you the meeting notes about this. So you have my email. Okay, go ahead. Sorry.
Perfect. No, that's perfect. Okay, so so that's kind of the specific stuff about Parkinson. I wanted to get that out there right away. Just I'm going to speak more generally now about Social Security process. If you can go to slide 14, you are on it. Okay, so remember, Social Security is an administrative court. We're a special court. We have our special judges. It's not like, the normal court that you see on the news or whatnot. These judges only hear Social Security cases, and they are not set up in counties. It's a federal court. So it's, there's some in Mount Pleasant, there's one in Oak Park, there's one in Livonia, there's one in Flint. It's not based on your county. And it's all divided up by zip code. Right now, because of COVID, interesting, Social Security is closed, but they are working remotely and our hearings are taking place on the telephone, and they have been for the last year. And which is good because we're moving right along as far as business. It's kind of weird not having a in-person hearing, but it certainly is good that people don't have to wait till the COVID's over to get a hearing. All right, so you can go to the 15. The next slide is the first step at the administrative hearing. It's the initial application. If you're filing for SSD, you can file online at ssa.gov. You can also call the 800 number. Remember, if you call the 800 number, they will set up an appointment in the future to file. And they aren't filing in other words, they're not filing the day that you call. So, get the call off so you can get the appointment. I put there some of the things that you need when you file. The most important thing are the names of your doctors, obviously, and the correct phone number and address, so they can get any medical evidence that they need. You can go to slide 16. These are sort of a common ways your initial application might get denied. Once again, the basic non-medical requirements, remember what that was? If you're working, that's a non-medical denial. Or if it's SSI, you have too much income and assets. Another reason is maybe your medical condition doesn't last long enough. Say you have this isn't really applicable to Parkinson's, but like maybe with MS, you can maybe have episodic flare-ups, and so maybe you have a flare-up for 6 months, and then you kind of go into remission a little bit, or you need to have a continuous period of 12 months, remember. So sometimes you get denials based on your condition hasn't lasted long enough. Now remember, the 12 months doesn't have to go by, but it has to expect it to last 12 months. So if there's signs of improvement, which Parkinson, I know there's not, they could give you what's called a durational denial.
Okay, there was a question, Kerry. Is there an age limit on the low end before you can apply?
18 years old.
Okay.
And then the other end, it cuts off at 65, because once you're in the retirement programs, you can't file for disability.
Right.
And that's conceptually, this is an important thing to know. Qualifying for disability is like you magically turn full retirement age. That's the amount of money you get. That's how they look at you. It's as if you retired, it's as if you were 65 or whatever your full retirement age is. And the other reason that it's good to file for Social Security, to say, oh, maybe I'm going to go back to work, I don't want to file, maybe I can find some work to do. All those years that you're waiting to file, it's not good. And the reason it's not good is if you end up never filing, what's going to happen when you retire is all these years are going to be averaged into your monthly amount and bring down your monthly retirement amount. So it's really important to file for disability. Sometimes I run into this and individuals are getting like long-term disability and they're like, I don't want to bother it. My LTD is fine. You know, my LTD company is just going to get my Social Security anyways. Why bother? You should bother. It's important. It's important to preserve your work record. So when you do eventually hit the retirement age, it's just going to naturally convert over into retirement. You're not going to have a problem.
I have a
Okay.
quick question.
Sure.
So you said that because of the assets, it may be denied. What do we mean by assets? Assets can be a house which you own and it may be 600K.
You can own a house and you can own a car and it doesn't matter the value for SSI. That's for SSI if you don't have work credits. Okay. You wouldn't be filing for SSI if you had work credits.
But one of the points was that your initial application can be denied if you have too much of income or too much of assets. So what is the definition of too much of income and too much of assets?
Well, too much income would only apply to SSI, okay? And it's $2,000 or less in the bank, two or more in the bank account. And there's actually, it's a little more complicated than that, but they basically are going to look at any life insurance you have, any burial expense. They're going to look anything that is an asset. They're going to count against you, but that's only for SSI. So, and remember, for SSI, they also look at your spouse's income. So if your spouse is working, you're not going to be able to get SSI. You only will be able to file for SSD based on your work credits, what you've paid into for FICA. Okay.
Good, thank you.
It's confusing, I know, especially when sometimes people file for both and you're just like, what? All right, just as far as other reasons that you might get denied, Social Security can't get in contact with you. They're going to say lack of cooperation. Drug and alcohol is obviously a big no-no. You know, that's a basis to get denied. You know, medical evidence, obviously, you need to have not just doctor's notes, but objective testing, things like that. And actually a warrant out for your arrest. And that's no joke, because even if, say, you got a warrant when you were 18 and it was in Florida when you're on spring break, that's going to come back and haunt you. You got to get it cleared up. It might sound silly, but the new systems they have now, I mean, in the old days when I practiced as a young lawyer, they never caught that. Now they do all the time. So you don't want to have any warrants out there, even if they're for silly things. The next slide on 17. If I'm going too fast or you want me to repeat anything, please let me know, Mary, okay?
Oh, you're fine.
This is the next step in the ladder. Remember, we're in the administrative ladder, okay? We got denied at the initial level. Okay, what do we do next? Plug along. You got to fight, okay? Because this is Social Security. The next level is called the reconsideration level. It's funny, Michigan did not have reconsideration for the last 20 years. So they just picked it up again like 2 years ago. And so now it is. It's a shame because it's kind of a ridiculous, they basically are rubber stamping your initial decision. It's unlikely that you can win at the reconsideration level. Once again, it's a paper shuffling stage. They're just looking at the paper, the medical evidence, and, you know, saying, well, maybe can we give another look at this? Maybe we made a wrong decision. Do we need to reconsider it? That's why they call it that. You can go to slide 18. Slide 18 actually applies to the initial level. It's like you might wonder, well, where does this go? Who looks at it? It's actually a body. It's called the DDS or the state agency, and they're the people making the decision. There's a person called a disability examiner assigned to the case, and they are coordinating all the evidence and writing your doctor, and then they give it to a panel of doctors to look at to see whether, you either meet a listing or whether, your RFC is good, and they can make an allowance. And that happens once again, both at the initial level and the reconsideration level. Sometimes, lawyers can help with talking to the disability examiners, seeing what they need. Some disability examiners are better than others. Some are really helpful, and they'll say, oh, the doctor really wants this. And you can't even get on the phone. It's really hard now because of COVID. They're working remotely. You can't really get too many of them on the phone. But we're all doing the best we can. At least they're open for business. You can go to slide 9. Oh, actually at the hearing level.
Yeah,
Back up to go to slide 19 real quick.
Okay.
If you can. It's just.
And, having a hard time with my computer. I apologize.
No, it's all right.
There we go.
There we go. So, this is me kind of complaining about reconsideration. Usually adds 3 to 6 months in processing time, and they don't change the decision. So we were kind of upset when they brought reconsideration back. Ideally, it's supposed to be, they're really supposed to be re-looking at it and getting new evidence and seeing whether they can change their decision. But in reality, that doesn't really happen. Reconsiderations too are taking about 6 months now. It really is delaying cases. Now we can go to 20. This is the fun stuff, the hearing level. So this is when you actually go to court. Once again, in Parkinson's cases, I think in many ways you can win at the initial level. Parkinson cases are good cases. I can tell you, I don't see a lot of them at the hearing level because we're able to win them at the initial levels, particularly if you have a helpful doctor. But if you do have to go to the hearing, once again, that's when you actually go to court, and you get a Social Security Administrative Law Judge. You might see ALJ, that means Administrative Law Judge, who will actually hear your case. And that's generally where most cases are won. And the reason being is that you're afforded an opportunity to provide testimony, and it just kind of colors in the picture of what's going on in your situation. You're able to talk about your daily activities and, give examples of ways, your life is affected and impaired by your, issues you may have. So, the judge listens to your story, so to say. And, there's a lot of good judges out there. And like I say, this is all they hear day in and day out. So many of them are very good at examining disability cases, knowing what to ask, picking up on a person's credibility, things that are important in any sort of court case. You can go to 21. Just kind of giving you, I don't need to go through all that, but that's just sort of the backdrop of Social Security court. The actual hearings, they're very short, relatively speaking, to a case, 30 minutes, 45 hour. They're non-adversarial. That means there's just your lawyer and the judge and someone who talks about jobs. In other words, there's not a lawyer for the government. It's a non-adversarial process. You're sitting in a conference room, obviously with HIPAA, everything you say is extremely confidential. In fact, with the phone hearings they're having, they patch you in through like the special software. So what you say is confidential, and you're not going to have any issues. Typically, you do not find out the day of the hearing. The judge doesn't announce the decision. So it needs to be reduced to a written form, and you get that typically about 6 weeks after your actual hearing date. These are just issues, once again, why a case may be denied at the hearing. Now, you really don't want to get denied at the hearing, because then you're going to get into the other levels of appeal that are very difficult to win. You really want to try to win your case either at the initial level or the hearing level. So your condition isn't severe enough. Being severe enough means that we're on 22. Severe means basically you don't have functional limitations that you could work or not work. In other words, you're able to still do some type of work. That's another thing to remember. Social Security, particularly if you're under 50, they are not just looking at whether you can do the work you had. You have to go a step further. You have to show you can't do any type of work in the national economy. They don't look at the ability to get hired. They aren't looking at the ability to get a job. They're looking at, hypothetically, given these parameters, whether this individual could perform that job that I'm describing, okay? It's a hard burden of proof, because they're going to look at very simple, repetitive, sit-down type jobs, simple sorting, things that would not require a lot of physical exertion, but you still have to do it, competitively, which means 5 days a week, 7 hours a day. I put that common reason, a previous denial by a judge. The reason why I put that is because that can be a big hurdle if you go to a hearing and you kind of like think, oh, I'm going to give it a shot, see if I win. Don't do that, because if you get a denial, it's going to be part of your case. It's going to be part of your Social Security file. So if you refile 3 years down the road when you're a little more serious and you think you have more evidence, that's going to be a great hindrance as far as any future filings. And last but not least, obviously, anybody who's going to be testifying and they're saying inconsistent things, not telling the truth, or saying they have level 10 pain 24 hours a day, that's exaggeration. That's a big reason why a judge may deny you. Should I just keep going, Mary? Yeah.
Yeah.
Okay.
Yeah.
Okay. Now I'm at the last step of the administrative process. It's called the Appeals Council. You have lost your hearing, which is not a good thing, but you're still going to fight it. So you have 60 days to file an appeal to the Appeals Council. And they basically are going to look at whether the judge made any errors in the decision. It's very rare that appeals councils do anything for you. I'd say maybe 10, 15% of the time. They most times will just follow what the judge has done on the case, unless it's a pretty clear error. So once again, when you appeal a case to appeals council, you aren't rebuilding the case. In other words, you can't say, oh, my doctor finally would fill out the RFC, here you go. No, you can't do that. The evidence is all in as of the day of the hearing. You have to argue the errors made in the decision. So in other words, you got to get that medical evidence in there by the hearing and preserve the record. So you can't submit it later. Slide 25, just trying to tell you things of when we're looking at appeal. I do a lot of federal court work. Less than 2% of the cases go to federal court. That's actually, you're starting a lawsuit against the government. It's a pretty big deal to go to federal court. And, you know, these are the types of things you're looking for if you do. Misapplication of the law and facts, inconsistencies in the decision, and you know, not giving weight to your treating physician's opinion. That's a big no-no. Once again, this is the last level, your last ditch hope to get your case approved. It's actually starting a lawsuit in federal district court. This is a little more on federal court. So, let me see, I have about 20 minutes left. Do you want me to field any questions, Mary, or on the administrative part, or?
Yeah, does, if you have a question, you can unmute yourself. There was a question in the chat box asking, whoever asked the question said there's 73. So obviously that's too late to apply for a Social Security disability because it's the Social Security income, correct?
If you're age 73, you're outside the disability program. Once you turn full retirement age, you can no longer file for disability.
Yeah, okay.
And because you're in the retirement programs.
Right.
That's why. So, yeah, that's correct. Okay, nothing else? Okay.
I don't
Yeah,
think.
I got a question.
Go ahead.
I applied for, well, let's go back. I got unemployed as of last March, about a year ago. During that time, I was collecting unemployment. I filed for SSD or whatever, and I was approved on that in September, but I didn't know I was approved way back before that. So I was collecting unemployment while my, what do you call it? The
paperwork was getting processed.
Yeah, they were starting to pay me because they don't send out.
You're okay.
check.
We're okay. Okay.
Well, it's complicated. Did anything happen yet, or you're just worried something might happen?
No, well, I'm worried that what I did, I then went and canceled out of unemployment. I didn't know if I was still.
Yeah, I would stop collecting it. Okay, but I can tell you this is an extremely controversial area right now, and I can tell you on the state bar board, even learned attorneys don't know the answer to this. But the bottom line is, from what I'm seeing, if you collected it, it's no problem. Okay, but it's a good idea to stop. Once you've been adjudicated disabled, you really should stop it right now.
Yeah, I stopped it right away.
Yeah, the verdict is not out. You know, part of it is because it's a pandemic, part employment, and we haven't gotten any directive. In the old days, I mean, you know, 20 years ago, if you collected unemployment and tried to get disability, oh boy, that would not be a good thing, because obviously you're saying you're ready, willing, and able to work, which is in direct contradiction to Social Security laws. So, you know, I've even had situations where there was a judge in Oak Park. He used to be an unemployment judge, and he would go crazy. I mean, he would like threaten to say you're committing fraud and all this,
Yeah,
and
that's
on
what I
and
wanted
on. You know, taken to the literal nth degree, that's technically correct. But we are finding that the courts are not doing anything about it. It's, I don't know if it's because of COVID and they're cutting you more slack, so to say. But there is no answer. We're just kind of going by what's happening now.
I
And
run into that a lot.
Yes.
yeah,
Because he was working, and then, you know, COVID got him laid off, and they said they wouldn't be calling him back. And then
Right.
during that time, that's when he applied for Social Security disability.
Sure.
July.
Absolutely.
Yeah. Or it was like
Oh.
6 months later. I'm sorry, Kerry. It was like 6 months later, but
So was there a period of being found disabled and collecting unemployment?
Yeah, but I wasn't aware I was okay.
How long was it?
3
Just like a year? Oh,
6
you're not-
months.
about
You're
6
not-
months.
You're not gonna have a problem.
Yeah,
Okay. Thank you. We're,
The other
yeah.
thing, and this is just to make you feel a little better, part of it is too, my understanding is you did not certify with Marvin, right?
I
no.
a week or
Because you
here,
weren't.
shut it off to see what he would then reply.
I don't think you had to for during COVID. I don't
Right.
think you did. So that's good. You never said you were ready, willing, and able to work. You never certified that you were.
No.
No.
That's what some people are saying. I mean, it's a way and it's a good thing that you didn't certify.
Okay.
All right,
So-
thank you.
I wouldn't worry.
Okay.
I really
Thank
wouldn't worry
you.
about it.
Okay. Thank you.
Dear.
If you send me an email, by the way, I just wrote an article in the news, the illegal news. I can email to you if you want to read it.
Okay.
Okay.
Oh, that'd be great. Okay.
Okay. There's a question from Dheeraj Sharma. Go ahead, ask your question.
So my
Unmute
question is,
yourself.
sure, thank you. Now, my question is that Spencer mentioned that to prove you are a disabled person,
Yes.
if you are 60 or above, it is a little easy for the doctor or anybody to prove it. But my
Yes.
age is 45. I'm just 45 years old, and
Okay.
I got young onset at 35, almost 10 years plus. I've been having PD. Now, my question is, what parameters or what things should I be very careful about, or should my doctor be very careful about to make sure the case becomes a positive case in which proving a disability is not a big deal. So what do I
Okay.
do? What can I?
That's a good question. The form, the medical statement form, your sure bet way is just to make sure that those symptoms are documented and that your doctor can attest to them. That would be the best way. I mean, you're not working now, or are you continuing to work right now?
He is working, but the situation is this: down the line, 2 years, he may not be able to.
Okay. So what I would do now is just, continue to go to your doctor, and once you stop working, make sure you have those symptomologies documented and your doctor's on board, and you should be okay. I mean, it's a double-edged sword. I mean, what I see from that fact scenario that you just gave me is a little trickier, because if you're working right now and your condition is pretty much the same as when you're going to stop, I mean, are you deteriorating, or you're going to need to
Yeah.
explain how you were able to work with the same symptoms that you know what I mean? And you can do that. You want to show maybe a slow progression. I mean, most judges are going to love the fact that you're working and you're hanging on and you're doing what you can do. I mean, they just eat that up. I mean, obviously you're very credible if you're doing that and whatnot. And if it comes to a point where you can't do it because it just, it becomes too much, so be it. But if it's just like kind of a straight line and it's the same, you want to either show that you're being accommodated at work, that your employer knows, like, you need to have more time or special sort of apparatus to be able to work at your computer or whatever it is. So you can show that, hey, look, I know I was, I had some of these symptoms and it was bad, but this was a situation. They really liked me. I was a good employee. They let me get a special desk. They let me take, more time, whatever it is. You want to maybe be thinking in those terms.
Yeah, so definitely, whatever the task, he is smart enough so he can finish his task rather than in 8 hours. He can finish his work in 4 hours. But definitely,
Right.
there are a lot of time. But as of now, he's working as a common employee, what other people do. But because of his smartness, but down the line, definitely this will impact. So should we work with our employer to show him that sort of part-time or reduce our work hours so that can become the strong point?
Well, you might want to just have some way to document that. You don't necessarily need to work with your employer, but you might want to have I mean, most judges, if you just tell them that, they're not going to, hey, well, prove it. You know, it's obvious from what you're telling me, it's true. And, you know, you could just relay it to your doctor. It could be in the medical evidence, you know, your doctor could write it in the notes. That's good. In the medical records, they typically don't write employers. That's not evidence considered in Social Security cases. Judges don't want to bother with that. You know, that's a whole another workers' comp. They don't like workers, you know what I mean? So no, I wouldn't write. I wouldn't work with the employer. I don't think it's necessary.
So should we work with our doctor always to take the note off, because we have a regular checkups every 4 months with doctor. So ask doctor to take the notes off, those kind of things every time.
I mean, if you want to, if there's an accommodation taking place, yes, I think there should be something in the note. I mean, it's helpful if you, it's not imperative, but it's always helpful to have some sort of insight, you know.
Got it.
The kind of work I do, in my kind of work, I'm not sure what kind of accommodations I can ask, because I have to be sitting in front of the computer on a chair, or going to different meetings, taking meetings, talking to the people, and this kind of work. So this is the kind of thing. Now, I have one more question for you.
Sure.
Now, there are two things I can go for: either long-term disability from my group insurance providers from the employer, or I can go for SSD, or I can go for both. So which one takes lesser time to get? And
well, the long-term disability is usually much quicker, but it can tell you that your long-term disability employer is going, insurance company is going to tell you have to file for Social Security. Many times that's a condition of the LTD benefit. In fact, I'll take that even a step further. When you get approved for Social Security, they're subrogated. They get those monies. They're reimbursed for those monies. So, you know, that's going to be part and parcel of what your policy says. I wouldn't have any way of knowing, but, you know, most policies are written that way. So, but remember, Social Security is a tax-free benefit, though. LTD is not.
actually, in LTD also there is an option, like when I enroll myself for LTD through my employer, he gave me an option in which I could pay from my pocket from $16 or $18 per paycheck, and the LTD money will be tax free.
Oh, good. That's good. Yeah, you know, I've heard of that. That's something that just started. That's somebody told me about that. That's interesting. Very interesting. But just one more thing, you know, when you say you're going to pick between LTD, remember what I said about freezing your work record.
Yeah.
You want to get the disability to freeze your work record. So when you retire, you haven't gone years without working. It's an important thing. And also minor children, obviously, get Social Security where LTD is not. Mary, I think I'm just gonna, because it's winding up, can you skip to 32?
Sure.
Because, and you know, my slides are pretty self-explanatory. So, you know, once again, if you have any questions, just email me. The reason why I want to just quickly end with this disability function report, you will get this when you file at your initial application, okay? It's 100% required, okay? And if you want the full form, I can give it to you, but I gave some samples of how to answer these questions. Basically, the function report is your ADLs, your activities of daily living. What you do from when you wake up to when you go to bed, whether you're able to cook, clean, do housework, that type of thing. So just some tips on how to fill these forms out. This is one of the questions. I'll give you a couple sample questions. How do your illnesses, injuries, or conditions limit your ability to work? So this is the type of questions that they ask. You can see they're pretty open-ended, and you're just like, I don't know, if somebody asked me that question, I'm like, well, wow, you know, how do you answer that? And they give you like 3 lines to do it, you know, so you don't want to overthink it, but, you know, you want to make sure you're emphasizing things that affect your ability to work. Are you missing work because of flares and symptoms, for example? Do you have problems concentrating or thinking? Examples of that. Obviously any sitting, standing, physical things, using your hands, bilateral manual dexterity, that's very important for working, being able to use your hands. So, it's, if you're doing things slower, I'll have clients say, oh yeah, I can do housework. And I'll say, okay, well, they're doing housework, but they're doing it for 15 minutes and then they're resting for 15 minutes afterwards. It's like, make sure you say that, You go to the next slide. This is another example of the question on the function report, which you will have to fill out. Describe what you do from the time you wake up to when you go to bed. Okay. And I think they give you 4 short lines to fill this. So, don't be afraid. Just get up. It takes me a little longer to get up, and you just put it in your own words, make it from your heart, but just, once again, don't try to minimize what you're doing, but at the same time, don't say you're in bed all day or something like that. I mean, unless it's true, probably an exaggeration is worse than a minimization. But the next slide, question 12, is on the function report. They're looking at personal care. How does it affect your ability to dress, bathe, care? Make sure you fill those things out thoughtfully. Once again, are you doing it slower? Can you not take a bath anymore because you can't get out of the bathtub? Does your spouse have to be close by the shower because they don't want you to fall? Do you have a shower chair? When you go shopping, do you use the scooter? Do you sit on the bench in the front while your spouse is shopping because, it's just too hard for you to navigate the store? Those kind of little nuggets help. They really do. And last but not least, they'll ask you about social activities. That's at the end of the function report. So, and sometimes judges like to know about social media. It's okay to have social media, but are you on it 4 hours a day? Or, you don't want that. But it's, I guess generally speaking, it's okay to be doing things. In fact, it's not credible to not be doing anything. You want to describe that you are doing some things, but just depict it accurately. I think that is it. I kind of went through that fast, I know, but you have at least kind of a little bit of a guide there. Once again, those handouts are about the listing and the medical source statement. I think that would be very applicable to any Parkinson case. And, perhaps you could even get adjudicated at one of the initial levels, so you wouldn't even have to go to a hearing, which would be, it's very stressful going through a hearing. I mean, you're going to court, so if you can get it approved at the initial levels, all the better. So were there any questions? Or once again, my email's at the beginning of the PowerPoint.
And folks, if you want the PowerPoint or if you want the form, just email me and I will send it to you, okay? My email is markInsonsmi.org. You all have gotten an email from me, or otherwise you wouldn't be on this program tonight, though, okay? It's Mary Sue Lanigan. All right, if we don't have any questions, Kerry, thank you so much. I learned so much tonight. I really appreciate it.
We
Oh, go
may not
ahead.
have we may not have your email address. Would you mind putting this in chat so we can just
Yep.
copy your email address from there?
Yep, I will do
And
that.
Mary,
right now.
yeah, my email is Kerry, Kerry, at ssrights.com. If you want to put that in there too.
Can you say that again slowly?
Sure. My
Oh.
first name's Kerry, Kerry,
Oh.
at like Social Security rights, ssrights.com. clever, SSRIGHTS.
Okay, I just put my email out in the chat box for everybody, okay?
Kerry, can I ask you something?
Absolutely.
Okay. I was diagnosed like 15 years ago with Parkinson.
Okay.
And so I worked part-time, like 2 to 3 days a week. But now my doctor doesn't want me to drive.
Okay.
So that sort of limits my ability to get to work and what have you.
The inability to drive alone doesn't qualify you for Social Security. Certainly it's part of the bigger picture of your functioning.
But my husband said, since I haven't paid it.
Well, part-time work can do it. You don't need to have to make that much money to have quarters of coverage. What I would recommend, and I actually recommend this to everybody, you should really set up a mysocialsecurity.account.com. It's a really good thing to either monitor your work credits or just to have, because you're going to need it eventually. So it's on, ssa.gov, and you just follow the instructions. It's called My Social Security Account. And you can look at your work credits and see if you have insured status.
Okay.
You already did that? Okay. So she doesn't?
No, I didn't. I have not done that.
Okay. Yeah, because you don't need to, you only need to make like, I think 2,400 and something a quarter to get a credit. Yeah. So it doesn't take much to get a credit.
Okay. But he said I didn't accumulate enough hours, over all these years to be eligible.
They don't go by the hours, they go by the amount of money that you're posted in a quarter. So
Okay.
The first sign of trouble.
Do they look at your husband's income?
no,
don't?
only if you're a widower.
No.
Okay. All right, thank you.
You're welcome. Okay. I guess that's it.
Any other questions? Okay. Well, Kerry, thank you so much. We are so
My
grateful.
pleasure.
This was great presentation. As I said, I think we all learned quite a bit tonight. If with your permission, I'd like to hang on to your presentation and post it to our website. We'll create a page for how to apply for Social Security. Is that okay?
That's fine.
All
Absolutely.
right, super.
And make sure you post maybe the medical source statement too. That might be helpful.
Absolutely. Yeah, we will for sure. Thank you.
All right, you're
right,
quite
folks.
welcome. Bye, everybody.
All right, folks, I'm going to end this meeting tonight. Okay. Thank you. And hopefully we'll see you all tomorrow at exercise. All right. Good night.
Thank you, Mary Sue.
Bye, Joe. Good to see you.
Yep, you too.